we're not grateful for ADA, but we are grateful to learn all we can about it. And I give you Senator Bob Dutton from the 31st Senate District to introduce our guest speaker. And thank you all for being here. Judy, what?
Good morning and welcome. We're hoping that today you'll be able to get some additional information that'll help you as small business people. You know, I came to the area about 37 years ago, almost 40 years ago, and as a young man and started a small business, and basically, you know, a lot's changed in the last 40 years. It's been a lot tougher, but I have a lot of passion for the small business operator because I know a lot of I can feel the problems. I know what the challenges are. So I've always made it my business to try to help small business people, you know, throughout my entire career as a small business owner myself, working through a Chamber of Commerce, but also now as a state legislature. One of the problems we're having today, as all of you know, there's a lot of abuse going on, not within the businesses themselves, but within some of the rules and regulations that you're having to deal with on a daily basis. And it's not so much that some of these are unreasonable, it's just that we've got a certain segment of the population out there that seem to want to take advantage of them for their own personal gain and not for what they're intended for. And that's exactly what has happened in a lot of cases with the Americans with Disability Act. It's not that it's a bad piece of legislation. It's not that we shouldn't want to improve access to businesses that are open to the public, but it's not right that somebody take these minor infractions like having a bathroom mirror that's 2 inches too high, or having the wrong color of blue on your parking stall, or expecting you to have some kind of designated parking area where there's no space available, or even have you as a business owner responsible for things that are actually the property owner's responsibility. So what we're going to try to do here is to help provide you with information and so that you can better protect yourselves. I strongly believe that if we can help improve the business climate for the small business community of this state and this region, that we actually can get ourselves out of this recession we're currently in. I often have said, too, of the power of one, and that is the small businesses of California represent over 700,000 employers. And if we could just help you save enough money through elimination of frivolous lawsuits and regulatory burdens that's placed on you to where you could just hire just one more person, we could actually reduce the unemployment in the state of California and in this region by 1/3. That's how much power the small business community of California and of this region has, and how important they are to the viability of not only our local cities like San Bernardino, but also of the region. Now, I want to thank this morning the San Bernardino Chamber of Commerce. I want to thank you for hosting today's event. Also want to thank Time Warner Cable for recording this event, because this will also be airing on the local channels so that other small businesses can actually take advantage of what you're about to hear today. I have introduced a bill called SB 1186. Now, this is my second attempt. This bill, real simple, for minor infractions, before you can be sued, give you 90 days to fix it. That's all. I don't think that's unreasonable. I think that makes, frankly, common sense. As a matter of fact, you'll find, by the way, the legislation in your packet. I would suggest you send letters and so forth of support to the committee. I did make an attempt last year to actually do a similar bill that asked for 120 days. They didn't like that idea, so I thought I'd try for 90 and see if 90 was more appealing than 120. I also understand that United States Senators Dianne Feinstein's looking into this. It's my understanding that she is supportive of this effort, and you may actually be contacted by her reps, her field, her office people. She wants to talk to small businesses and find out, exactly what kind of problems you're having. She feels it's also critical too that California is one of 5 states that there seems to be the greatest amount of abuse, and so we're hoping to have her support, as well in trying to get this legislation through the state and through the state of California. Also, now at this time, I would like to introduce somebody who knows, you know, a lot more about this than I actually do, and that's an attorney by the name of David Warren Peters. He's with Lawyers Against Lawsuit Abuse. He's going to lead the presentation, and we also have a certified access specialist, Mr. Heller, who will also be here to answer any questions that you have. I'm hoping that this information will be valuable to you. When I was active in my local Chamber of Commerce, the biggest benefit I felt I had as a small business owner in the Chamber of Commerce was information and knowledge and ways to help myself. You don't have the money necessary to hire a full-time person for human resources and to deal with these kind of liability questions. The Chamber of Commerce affords you the comfort of knowing that you got somebody there that's going to help you and at least provide you with the information. And information right now I think is key to helping you be a more successful business. So without further ado, I'd like to turn it over to David.
Thank you, Senator.
Thank you.
Thank you very much. Before I begin, I just have to say I have seen your Chamber's Judy Penman up in Sacramento fighting tirelessly for you on this issue. I also want to recognize Sharon Bleckinger of the Mexico Cafe in San Bernardino. She was also among a group of gutsy local defendants who decided they weren't going to do things the way that everybody else does them, and as a result, the first criminal investigation that went anywhere was triggered into these lawsuits, which is still helping us today. Some of the documentation, some of the work that Judy and Sharon did is still out on the internet helping us and something we can point to. I also want Marianne Maloney, if I could also recognize Marianne Maloney of California Citizens Against Lawsuit Abuse. As you look through this presentation, if you think this is a great way to enforce the law, meaning through private lawsuits or profiteers, cloak and dagger, however you want to describe it, great, do nothing. But if you don't, and many of us don't, then I would suggest talking with Marianne. The CALAs have been, again, Citizens Against Lawsuit Abuse groups around California, have been very instrumental in creating legal reform, and you know, we did it with Proposition 64, the Stop Shakedown Lawsuits Initiative, and I still get calls from people almost every week, and I'm hearing, hey, I thought we voted to end the shakedown lawsuits. And the answer is yes, we did. But in California, new claims are concocted almost on a weekly basis. And we were, well, in a recent count, we concluded that there have been at least 25,000 to 35,000 ADA accessibility lawsuits in California alone. Over 40% of the ADA lawsuits in the United States are filed in California because there's a unique combination of laws that makes them incredibly profitable here. Some say it's more profitable than narcotics. As a result, and we think 98% of the small businesses out there would be subject to one of these claims. Having said all that, well, I'm going to jump into the presentation. I will be showing you pictures of conditions that support these claims. If you see conditions at your property that look anything like the pictures you're seeing in this presentation, you're probably a prime candidate for a lawsuit. And I've said for years that the average small business can fix most of what it needs to fix for less than $1,000. If you get sued, I think the average small business starts running up a bill of about $5,000 to $10,000 or more. And we've seen some defendants whose names you would recognize, like Clint Eastwood and others, spend $500,000 or more dealing with an ADA lawsuit. These lawsuits have closed many businesses, and while the law was very unclear for many years and could still be improved, you do have the power to make sure that yours isn't one of them. So with that, could I ask the gentleman in the back to switch off the house lights? Great, thank you. And, Senator Dutton introduced Philippe Heller, but I just wanted to say a few words. Philippe has, he is a certified access specialist. There's a new law. I was one of the people who worked on it, and you know, the legislature concluded that there were too many self-educated, self-appointed, so-called experts that were not giving people accurate information for what they wanted to do, or what they needed to do. And Philippe has been doing this long before the law passed, but he is one of the first certified access specialists to be licensed in the state of California. He has helped our clients all the way up to Sacramento, and certainly in this area. And so I asked Philippe to come here to help perhaps with any technical questions that you may have. Since we're starting a little bit later than I would have liked, I'm going to ask, if you can, hold your questions until the end. I will stick around as long as there are any questions that need to be answered. I'm sure Philippe could hang out a little bit as well. And with that, thank you for waiting. I'm going to jump into the presentation. There are just a few preliminaries. Number one, this presentation is not legal advice. Every property is different. Every plaintiff, every claim, every judge is different. There's no substitute for getting specific legal advice about your situation and your property. It's also important to keep in mind that for many of the things I'm showing you, tax credits and tax deductions may be available. I can't tell you that they are. You should talk to a qualified tax advisor, but it can sure help with the cost of making these changes. Also, please keep in mind, you may not be required to make any or all of the changes that I'm going to show you. When I'm showing you the way things should be, in a landlord-tenant situation, you may not be the one that's required to do them, but you need to be looking at this. And if you don't have these things, you can get a very costly surprise. So, worth keeping in mind, February 26th of '92 was the last day to comply with the Americans with Disabilities Act. If your business is open to the public, this is a matter of civil rights. You are required to be accessible to people with disabilities. In the same way, you couldn't have a sign over your door that excluded a certain race or gender or political persuasion. If you have conditions at your property that could keep someone with disabilities out, like if you have 3 steps up to your front door, and that's the only entrance, that's a civil rights matter. California is the only jurisdiction on the planet that has what some people call a bounty on these claims. California has a statute, Civil Code 52A, that provides $4,000 plus attorney's fees if there's any discrimination or distinction in the way you provide goods and services to people with disabilities. It's a hopelessly vague law. There's certainly room for improvement, and I'm so thankful to Senator Dutton, who I also have seen working tirelessly on this issue in Sacramento, and others who are trying to get some clarity. Very important, does this work? A lot of people tell me, I never got a letter, I never got notice. They do not need to send you a letter before filing one of these lawsuits. The overwhelming majority of my clients don't get a letter before a lawsuit is filed. Just a few more preliminary comments. Actually, we talked a lot about this, so I'm going, okay. Well, before we jump into the pictures, every time we do a seminar, someone leaves thinking it doesn't apply to them. So if you'll indulge me just a moment, I want to go through some of the main misconceptions that I've had people sit through the seminar and then they tell me later they're sued. So just very briefly, everybody thinks they're grandfathered. Grandfathering applies to building codes. So for example, your home is probably grandfathered. And what that means is that if the building complied with all applicable building codes in the year it was built, when we have a new building code come down, you don't have to make the changes to upgrade it. That makes sense. However, if you are involved in a business property that's open to the public, like I said before, these are civil rights laws, and to some extent that trumps the building codes, and so you don't have to be open to the public. You can use your property as a warehouse or any number of capacities that aren't open to the public. But if you want to invite the public, you need to be accessible to all members of the public. People tell me, my building complied when it was built. We've been inspected, the lottery inspector came out, the health and safety inspector came out. These are different issues. Most of those inspections involve different standards, and many of my clients have passed all permits and fully complied, and they're still being sued right and left. People say, no one told me about these requirements. Well, in that regard, you have my sympathy. Most of the things whenever business gets a notice, they tend to make the changes. But for some reason, those in Sacramento think that this system of gotcha lawsuits is a better way to go. And they will point out that no one told you about labor laws or collecting sales tax or environmental laws, or if you have a pothole on your property, you're going to fill it so that you don't get sued. They think this is the same sort of thing, and I would disagree with that. I hear people say people with disabilities have come and gone for years without mentioning problems. It is important that you understand that there are a core group of professional plaintiffs who have demanded more than $1 billion from California's small businesses just like yours. They find it, if they sue the big chains, they get a very aggressive defense. What they find is that by suing people who can't afford to defend, they're almost always going to get a quick settlement check, and it may only be a few $1,000s, but if you file 100 lawsuits a month, you can make a very tidy living doing that. It is often not about the condition in question. We've seen lawsuits about the color of a sign, the word handicapped. I could go on and on, but you'll see some examples. People say, whenever I see a wheelchair, I go out of my way to assist. Whoops. And that's great, but this is about equal access and independent living. We know one business that was sued because it was too helpful. If there's a way that you can make something equal access so that someone in a wheelchair can have access to it the way any of the rest of us can, that's what needs to happen. I've had people say, we would have carried the plaintiff in. We would have gone out to their home, but this law is 20 years old, and the point of the matter is that someone should be able to come in and serve themselves the way anyone else can. This is like the last one I mentioned. People will say, well, all they needed to do was ask. We have a ramp around back. If they had just looked around. Well, some people can't. Some people have physical conditions like COPD, and they can't travel long distances, etc. And frankly, if they drive up and they see 3 steps or even 1 step up to your front door, they may assume that you're not aware of these standards, and under the law, they can just go file a lawsuit. So if you have alternatives, you need clear, very conspicuous signs to them. If you've got steps up to your front door, then I would suggest right next to those steps, you ought to have a big sign letting people know how to get to the ramp. The opportunist will take a picture of the steps, but if you've got a sign that's so conspicuous that it's going to end up in the picture, then what are they going to do with that? They'll go down the street. I point this out, I'm not kidding. We have seen necktie cameras, hat cameras. I know a guy with a belt or a belt buckle camera, and we get these beautiful high-definition videos from plaintiffs' attorneys. A lot of people think, well, you'd really have to have someone come into your business and there's going to be an incident and you're going to know about it. The fact of the matter is, in the overwhelming majority of cases, you don't. We've seen on videotape, we have videotape of scouts surveilling premises, and keep your videotapes for a couple of years if you can, because it can be, you can always, you see the scout behaving in a very different manner than a real customer would have. But unfortunately, it is the reality that they can take very quick measurements and photographs, and so the odds are you will not know if your premises are being targeted. Many people think these lawsuits were not intended by legislators or judges, and the interesting thing is, that is correct. I'm one of the people who've gone back and I dug videotapes up in Sacramento, and we've looked at the record on the ADA, and I am absolutely convinced that what you are seeing today, strictly speaking, was not intended by the legislators who brought these laws into effect. The problem is, as judges will tell you, there have been 13 failed attempts to make a change, and Senator Dutton was one of them. I saw him up there fighting for you, and with a very common sense provision that I couldn't see any good reason for voting against. But the fact of the matter is, there are now about, I think, 9 reform measures this year currently being considered. But again, remember that 13 have failed, and you've got to assume this is not going away. Even if the reform measures pass, if any of them pass, you're still, nothing's going to relieve you of needing to have disabled parking and the other things you need to do. And the judges point out that until the legislators change the law, this is it. A lot of people say, I'll just copy the codes. It's important to keep in mind that, again, California is unique on the planet. Our building code and our standards conflict directly with the ADA in a number of important respects. And so we have never seen a business owner get it right. In fact, we've seen many design professionals, architects and otherwise, get it wrong by trying to reconcile the codes. It's extremely confusing. We often, we get 3 experts in a room and they all disagree. Be extremely careful about that. As I mentioned earlier, you can't just look to the ADA in California. You go to ada.gov or you call the Access Board in Washington, you will get, or you may get, unreliable information. Under California Civil Code 52A, it says any discrimination or distinction, and the non-compliance with the ADA is just one of many ways that you can be sued. And so I've got a desk full of clients who complied with the ADA, who went out of their way to figure out what do I need to do. They looked at ada.gov and they're still being sued. Associated with that, people look down the street. They look at the big chains, and I won't name them, and they say, well, this mega complex, their disabled parking is this way, and their paint is all brand new. It must be right. I hate to tell you, 98% of the businesses we see have a condition that would support one of these claims, and the big guys are getting sued as well. So you can't look down the street. It can be a big mistake. Also, if you look online, you will see that you can, I believe ada.gov talks about temporary ramps, flip-up counters, things like that. The deal, though, is that you can do those things if you can't afford to do it properly. The problem is, if you do that, plaintiffs' lawyers will say, okay, well then let me see your books back to 1992, because we think you would have had the money to do it properly, and this is what's called an alternative facilitation, or you're saying, I only need to do what's readily achievable. Well, only if you can't afford to put in a proper counter or do a proper fix to that step at your front door. So be very careful about things like that. A lot of people think that their landlord or tenant indemnified them. You're probably going to find in the ADA context that indemnification may not be reliable. So don't, the key is, what should be happening is that landlords and tenants should be sitting down together, looking at this 20-year-old law and figuring out what are we going to do to comply. That's what should be happening. The problem is that you've got a lot of standard provisions in lease agreements that the landlord thinks it's the tenant's problem, the tenant thinks it's the landlord's problem, so nothing gets done, both get sued, and they both end up writing checks. Another biggie, we are seeing more and more defendants who have been sued 3 and 4 and 5 times in these cases. In this economy, once is too often for many businesses. I hear people say, hey, I was sued, I made all the changes in the complaint, and I should be golden. Actually, it's important to keep in mind that the overwhelming majority of ADA cases list a subset of all the items on your property that could support one of these claims. There's two major reasons for that. Number one, a person with disabilities only has standing to bring claims about their disabilities. So if someone in a wheelchair comes along, yes, you can be sued on the wheelchair claims for the things they encountered or that they observed. But then if you have someone who needs Braille, that's a whole different issue. And there are other types of disabilities as well. So there's another reason some attorneys actually like sandbagging these claims. They like, and we finally got documentation of that in the Ninth Circuit decision of Oliver v. Ralphs. They finally got a mega filer to admit that he does customarily hold back claims so that he can prolong the litigation. He basically said that if he told the defendants what all the issues were, they'd fix the problems and move the case, which won't always work. Here's a biggie, and I think this is the last one. You hear a lot about the new 2010 standards, and you hear a couple different things. Sometimes people say, well, California has a higher standard, so I don't need to pay attention to the 2010 standards. That's wrong, because there are differences, and the answer is yes, you do, and we'll talk about some of the differences. The other thing you hear people say is that, well, I've heard that if I complied with the 1991 standards, there's a safe harbor, and I don't need to comply with the 2010 ADA standards. Well, strictly speaking, that's true. Here's what the plaintiff's lawyers will tell you. They will say, but nobody complied with the 1991 standards. And I have to admit, we find very few businesses that have done that. So what you have is a situation where a business thinks they complied with the 91 standards, so they don't comply with the 2010 standards, they get sued, and the plaintiff's attorney is saying, okay, fine, prove to me that you complied with the 91 standards. If I find one way that you didn't, you needed to comply with the 2010 standards. So I think you need to take them seriously. Also, as you see down here in the corner, regrettably, everything is not in one place. There are other, the health and safety code, the financial code, the vehicle code, those all have provisions that could be relevant to you. So once again, when we hear businesses talk about, oh, I'll just read the codes, it's not as easy as it seems. All right, now, thank you for your patience. Now, in section 2, I want to very quickly go through some images that if you see conditions like this on your property, the odds are you may be looking at a lawsuit very quickly. First of all, parking continues to be the single most common source of claims. I would estimate 95–98% of the cases that go across my desk involve parking. There's two reasons for that. The cynics will say, oh, these are drive-bys. The advocates will say, or the plaintiffs will say, well, I use a ramp van, which I'll show you a picture of. If I can't park, I can't come into your business. So yeah, the law allows me to drive by, and if you haven't gotten with it in 20 years, then I am going to file a lawsuit. The other reason, this is what the judges will tell you, is that parking is one of the easiest things to fix. So it's a slam dunk from the plaintiff's attorney's perspective, in that they will say, they'll come in with a beautiful